Mr. Chairman, Mr. Ranking Member, and members of the committee, thank you for the opportunity to testify on the case backlog currently facing the Commission. My name is Mary Lou Jordan, and I'm Chairman of the Federal Mine Safety and Health Review Commission. The Commission is an independent, adjudicatory agency that provides trial and appellate review of the legal disputes that arise under the Federal Mine Safety and Health Act of 1977. The Commission's administrative law judges decide the cases at the trial level, and the 5-member Commission provides the appellate review. When I became chairman last August, I was confronted with a growing caseload that was a dramatic departure from the trend that had previously existed. For example, during the 4 years from fiscal 2002 through 2005, the caseload ranged from approximately 1,300 to 1,500 cases. In comparison, during the subsequent 4 years, from fiscal year 2006 through 2009, the caseload climbed from approximately 2,700 to over 14,000 cases. Currently, there's a backlog of approximately 16,000. Comparing the new case filings during these same 2 periods is also instructive. From fiscal year 2002 to 2005, the annual number of new cases filed increased from about 2,100 to 2,400. The figures after that paint a different picture. Case filings went from 3,300 new cases in fiscal year 2006 up to approximately 9,200 new cases in fiscal year 2009. The influx of new cases has led to a slower disposition. The vast majority of the Commission cases result in settlements. The settlement motions are reviewed by a judge who issues an order approving or disapproving the proposed resolution. The average number of days it took to dispose of these settlement cases increased from 178 days in fiscal 2006 to 401 days in fiscal year 2009. When I became chairman, I learned that the increase in new cases had created a bottleneck in the case assignments. By the time the cases could be assigned by the chief judge, they were already a year old. With the assistance of some contract clerical help, we've made progress in reducing the number of cases waiting to be assigned. However, unclogging the assignment process meant that the bulge of backlog cases would now move to the judges' desks. Judges' dockets have increased dramatically. From fiscal year 2004 to 2008, each judge's docket averaged 176 cases. To date, in fiscal year 2010, the number of cases assigned to each judge has risen to an average of 746. Under our budget for fiscal year 2010, the Commission plans to add 4 new judges to our current roster of 10. We also plan to add 4 law clerks and additional clerical assistants. These measures will allow us to slow the rate of the growth of our backlog. The President's 2011 budget request of $13.1 million will allow the Commission to stop the backlog from increasing. We'll be able to bring our total judges to 18 and plan to hire enough law clerks so that each judge can have the assistance of a clerk and share an administrative assistant. In addition to increased staffing, we're looking at all of our processes to see what we can streamline. Within the next few days, the Commission will publish an amendment to its procedural rules. We'll require the parties to submit a draft settlement order when they file their motions to settle with our judges, and these will be required to be filed electronically. We're also contemplating things like a calendar call where judges take a bundle of cases with a particular operator, meet with the parties, and try and resolve as many as they can. We're looking at whether we can simplify or even eliminate some of the pleadings that the parties currently file with us. And we're enthusiastic about looking at the possibility of initiating a simplified procedures process similar to that used by OSHRC, wherein things like discovery and post-trial briefs are severely limited. We're keenly aware of Congress's concern that the penalty provisions of the Mine Act cannot operate as effective deterrent if there's an unduly long period between the violation and the payment of the penalty. Indeed, the legislative history of the Mine Act that created the Commission emphasized that, quote, to be effective and to induce compliance, civil penalties, once proposed, must be assessed and collected with reasonable promptness and efficiency, end quote. Moreover, unless the case processing mechanism operates efficiently, operators who dispute MSHA's interpretation of a standard may not know in a timely manner whether their practices comply with the standard or not. We recognize that several important enforcement provisions of the Mine Act depend upon a determination of an operator's history. and these provisions are not applicable until the violation becomes final, which occurs only at the completion of the Commission's review process. Thus, if case decisions are delayed, the ability of MSHA to effectively enforce the Act may be inhibited. Thank you.